Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott complimentary webinar titled EU Pay Transparency Directive, Compliance for U.S. Companies. This webinar will be recorded. Today's presenters are FortneyScott attorneys David Fortney, Elizabeth Bradley, and Sarah Mugman. I will now turn the program over to David to start the webinar.
Thanks, Sarah, so much. And Liz, good to be here with you.
Hello.
Yeah.
Thank you for inviting me.
Yes, of course. And Sarah?
Happy to be here today.
Absolutely. Well, listen, let's get right in. We want to be smart about your time and talk about this EU Pay Transparency Directive. For those of you that are not familiar with our firm, we are DC based. We deal a lot with the US federal agencies, and increasingly we're starting to deal with some of the EU related agencies with respect to pay and other matters. That's really a function as our clients, many of which are multinational, as their issues spill out beyond the borders of the US and helping to assist them. So just a quick note that obviously we are going to be talking about some of the most recent developments. Although we're talking about topics of legal nature, this of course is not to provide legal advice, but we will be discussing legal developments. All right. Well, let's get right into what we want to do with our time today. We're going to spend about 60 minutes. I want to first just briefly touch on a compliance network, an EU Pay compliance network that we're very proud of and have stood up to help clients deal with these issues. We then want to give everyone a nice introduction to this new EU Pay Transparency Directive. We want to drill down a little bit on the EU member states. That's the term of art. That means countries or nations, what's called transposition, and we'll explain what that term means. Then we'll get into what the actual Pay Transparency Directive requirements are, and then finally round out with some compliance recommendations. So without further ado, let's dive right into it. First, let me just briefly mention this compliance network. I think this is really great, and it has really come about because we realize, obviously, with our clients, we're all very familiar with U.S. pay compensation, and many of us have been doing this for decades, and dealing with whether it was the former OFCCP requirements, Title VII requirements, state law requirements. But as this new pay transparency directive has been introduced, it quickly became apparent to us that not only did we need to have EU counsel involved, but we needed to have counsel in all of the key countries because each country is potentially different in how the directive gets implemented. So what we've done is really handpicked every one of the counsel that you see there, covering literally from Austria through Spain, and the major jurisdictions, and we have other counsel that we work with as needed in other countries for clients. So this is a great resource and one that we've really enjoyed with and been working very intensely with over the last couple of months.
As a bit of a teaser, today's focus is a general directive and the compare and contrast to some U.S. legal constructs. But there's also going to be, as this gets transposed by the different member states, we anticipate we're going to be partnering with some of the faces you see on the screen to compare and contrast how the various member states are implementing it. So we're looking forward to that once it gets more broadly transposed.
Absolutely. All right. Well, let's dig right in and share what we've been learning ourselves and with our colleagues in the network.
Sure. We're going to start with just an overview of what the requirements are on the next slide. So the goal of the directive was to promote salary transparency and reduce the pay gap and increase accountability in pay practices. So that is the thread that is going to link together all of the various requirements in the directive. The major components of the directive, there are wage notices to both applicants and employees, and we're going to talk about those in more detail. There's very detailed pay reporting that goes not only to the member states, but ultimately it goes to your employees and your workers' representatives. We're going to tease that out in more detail. And in addition, there is information disclosures, that transparency obligation to both applicants and employees and the workers' representatives. So there are some pretty detailed requirements, and we're going to start walking through each one of them as we move forward.
Alrighty, next slide, please. So before we kind of get into all of those nitty-gritty details, just to kind of give a little further background here. So this directive was, of course, adopted by the EU back in 2023. And just as of a few days ago, this past weekend, on June 7th, each of the EU member states had a deadline to transpose the directive. And that really means that the EU member states must either have enacted its own legislation or amended its current EEO-related laws to include the obligations that this directive directs.
So what's important to note here is it's not self-executing on the member states. Affirmative action needs to be taken by each member state in order to either transpose it, and that can either be done by essentially a full cut and paste into their law, or what's called gold plating, where it's customized to meant to kind of meld into existing member state laws. So that's something I think on the next slide we're going to talk about. Where are we with the transposition, and what does that mean if it hasn't been transposed yet?
Yeah, so let's go to the map, if you will, and look at the European Union, and there it is, and all those colors. If everyone had met the June 7th deadline, that map would be green. So obviously, only a handful of people, with Italy being the only major jurisdiction in terms of where most of multinational employers are having work done, that has fully, as Sarah's explained, transposed or implemented the directive by enacting it as part of its laws. The other countries, and I must tell you, this was kind of a surprise to me. I had assumed if June 7th, I mean, as Sarah indicated, this legislation had been pending for years. I actually thought the countries would line up, salute, and say, great, we've got it done. And as you can see, it's a real mixed bag. Some countries have done some good efforts. There's been a flurry over the last 2 weeks of people doing things, but not so much. And I would say what I was most surprised with, Sweden has launched a challenge saying that the entire directive is overreaching, encroaches unnecessarily on Sweden's autonomous legislative structure and their own practices. So this is a very interesting debate, and one that I think does not normally occur in the EU, because part of the arrangement was that there would be certain overarching common laws and standards that would govern when you become a member of the EU. Nonetheless, this and not surprisingly, Sweden has said it's too onerous, it's too rigorous, and it encroaches on our laws too much.
So there's some interesting questions that this raises. What is the impact on both employees and employers in member states that have not transposed the directive yet? A German judge recently stated that he believes that employees still have rights under the directive, under the EU directive, even if the member state has not transposed that law. So then that raises the question of, well, who would they raise that concern to? And if the member state hasn't transposed the law yet, are employers required to comply yet? We're hearing through most EU counsel, no, employers are not required to comply with this until the member state transposes the law. So there's still a lot of unknown and uncertainty.
Yeah.
But I think it is important to understand that we have seen a lot of activity over the last few weeks, and more things are moving green. And I don't think the slow implementation or transposition should mean that employers with employees in any of the member states need to pause and just wait and see. There's a lot of good work that needs to be done proactively so you're prepared.
And I think most jurisdictions look like in the reasonably near future, they may not have hit the June 7 deadline, but within the next, say, 90 days or so, they're getting themselves on track. So subject to what happens with that legal challenge by Sweden, which I'm too early to predict. All right. Well, so it's kind of a mixed bag as to which country. One key takeaway already is depending on where your multinational workforce falls, which country, you need to monitor and stay abreast of where you are in terms of where your operations are located. All right. Well, let's dig right into what the directive is a little bit.
All righty. So first we have who's going to be covered under this directive. And, it's really demonstrated by this. Really, this is the exact language that we've taken right out of the directive here. So on the first one is who's the covered employers, and that's going to be both public and private sector employers. And then furthermore, there's also the definition of covered workers, which is likewise broad, because it really extends to anyone who has an employment relationship as defined by member state laws, collective agreements, and in practice. So the directive itself really identifies covered workers to include full and part-time employees, fixed term contract employees, temporary agency workers, management roles, things we don't typically see in the US, right?
Right. Well, this is a much broader definition. So one of the key points is if you're a US employer and you're looking at this definition of employment relationship, our mind immediately goes to who is a W-2 employee. That's our default into the definition of that phrase. This language here shows that the concept of an employment relationship in the EU is much broader. For example, contract employees, meaning employee that we often think of those as independent contractors, right? Or temporary agency workers. Is that individuals who are provided to them by an employment agency? We generally do not consider those individuals as having a employment relationship. So when you're looking at your workforce and determining which employees are going to be required to be in some of the reporting obligations or counting your employees for, in this term, it's workers, for reporting obligations, be sure you put your EU hat on and use the broader definition of employment relationship.
Yeah, and that point that you've just made, putting your EU hat on, that is going to be a continuing theme. We're going to try to really lean into the fact that all of you are US compliance experts, and to sort of contrast and compare a little bit as we work through some of these concepts, because many of the core concepts are different. So do not follow your US law concepts, because that will not lead you to compliance. All right.
On the next slide, we're talking about the pay transparency obligations for applicants. So this is one of the first places where this is the pre-employment pay transparency required by the directive. They're fairly straightforward. You need to disclose initial pay and pay range, and here's a piece, relevant provisions of applicable collective agreements, lots of words, in your job postings and into applicants' pre-employment. There is a prohibition on inquiring about pay history. You have to ensure that vacancy notices and job titles are gender neutral. And you also have to ensure that recruitment practices are led in a gender neutral manner. But these are pretty straightforward.
Yeah, and I think, kind of easing everybody into putting that EU hat on, of course, this is probably the most familiar, right? Because in a lot of states, there are already these obligations to disclose pay ranges, and also to the prohibition on inquiring about pay history. And to the extent that, ensuring vacancies and recruitment processes are gender neutral, most employers have already adopted that as best practices here. So while these are now obligations, under this directive, still familiar here, I think, with US-based employers.
I do think, and this is going to be something I'm teasing out in the next slide as well, the affirmative obligation to ensure that your notices and job titles are gender neutral, and the affirmative obligation for the gender neutral manner in which you do recruitment, I think is a little more heavy-handed than what we're seeing here in the US. And we have another example of that on if we move into the next slide.
Yeah, so let's talk a little bit about transparency requirements with respect to setting pay. In the U.S., as you know, other than we have a series of requirements, generally speaking, that says what you cannot do, what you are prohibited from doing. I can't pay people differently based on their protected status, based on their race, their ethnicity, etc. But we were talking, we can't think of anything where we have specific prescribed requirements in how we set pay.
So here in the EU directive.
But here we go. Exactly. And so in this respect, this is a little bit, I mean, the critics of the European Union talk about the nanny state or the highly prescriptive environment. I think this is a good example of that, whether we use that term or not. But the law, once enacted, will require employers to have objective, gender neutral criteria to determine pay levels, and pay progressions that are easily accessible to workers.
This is meaning you're going to have a written document that is this objective, gender neutral criteria for developing pay. And I think you said the nanny state. I think another way to thinking about it is in the US, we tell you what you cannot do. You cannot discriminate. You cannot make decisions based on. Here in the EU, it's more of telling you what you must do and how to get to that end result. So again, a little bit more obligations, and you should be looking at your existing pay structure, your existing documentation on how you set pay. And especially if you are a US company that has a single pay structure, pay document that you apply across your organization, even to those in the EU, be taking a close look at that and making sure it hits these, specifically looking at skill, effort, responsibility, and working conditions. Those 4 words we're going to talk about in a little bit more detail, but they too are a thread throughout this directive.
They sure are. And I just want to underscore that, because those are the 4 criteria that pay structure needs to be based on. That whether it is or isn't, and to Liz's point, mapping or making sure our current pay structure can map onto skills, effort, responsibility, and working conditions, and meet those requirements. Because now the expectations in the EU countries, once the transposition occurs, is that your pay, in fact, is structured in that manner.
The pay transparency moves on to, and the next slide, employees' right to information.
Yeah.
Oh, yes. So, workers under this directive are going to have the right to, really request kind of specific pay related information from their employer. And that's going to include, information that is about that requesting workers' individual pay level, but also this average pay level as broken down by sex for that employee's worker category. I also think as Liz mentioned earlier too, there is going to be this kind of proactive obligation to annually inform workers, of this right to receive that information, and also explain the process for exercising their right to obtain that information. And then, of course, lastly, there's the directive's prohibition from preventing workers from discussing or disclosing their pay. And this concept is not entirely new here in the United States. Of course, both federal and state laws kind of add some prohibition on that type of conduct, but there's now this broader coverage under the EU directive.
These notice requirements, I was just thinking in the US, we're used to maybe putting a general EEO poster up in the workplace, electronically or otherwise. So this is, again, a little more fulsome notice. It will become easy to do. I think you build it into an annual email, that type of thing, to the workforce. But this is the type of thing that is relatively low burden, easy to comply with, provided that you kind of have your house in order and have developed those protocols.
Right. This can be bolted into some of your practices you're used to doing.
Right.
It can be replicated. The key difference is the level of information that employees are allowed or required to be provided with regard to the pay level of their peers in their worker category. So that is a new piece. And I think here in the US, we're sort of allergic to that concept that somebody could say, hey, tell me all what the pay level of all my peers
Wouldn't you like to make such an inquiry? And here's how you do it.
Exactly.
Here's how you do it. So please submit them. Yeah. So we think, and obviously from a policy standpoint, the directive is intended to create broad awareness and to
increase transparency
and increase employees' interest and from the regulator's perspective, desire to engage and call their employers out and say, provide me with that information. All right.
Keep moving. The next significant piece is the worker categories.
Yeah, so these worker categories, we're gonna, kind of go around this circle in a significantly closer detail in a moment. But really the key takeaway here is that worker categories serve as kind of this core component underpinning, several of these obligations under this directive. So we've just touched on how it comes up with the right to pay information, but again, it's also going to be relevant to pay gap reporting, joint pay assessments, which we'll get into much closer detail. So key point here is worker categories. Understanding them properly is going to really kind of lay the foundation for the rest of your obligations.
Liz, I'm going to lead the discussion on this. I mean, but this is something, folks, this I think is the kind of the core function, because if we don't get this right, then everything else will not be aligned and your whole compliance program will be out of kilter. So this understanding worker categories, which is a whole new concept, it's imposed by the directive, it's technical in nature, and getting it right is essential. Yeah. So how do we do it?
So the definition of a worker categories and how to develop them is set by the directive. On the next slide, we can talk through this. I want to lead by saying your worker categories in the EU are not your US EEO1 categories, and they are likely not your Title VII or other US-based law SSEG, similarly situated employee groups. They are going to be different. So in the EU, the appropriate category, a grouping of employees, is those employees who perform the same work or work of equal value. Okay. Work of equal, that's going to be the different, same work, I think we all pretty much can get that. The work of equal value is where you're going to have to spend time in developing these categories. And so the directive requires 4 criteria be considered there, and you could also, there's other things you can, business related and gender neutral, could be put in, but at a minimum, these 4 criteria: the skills of the positions. This is your expertise, knowledge, qualifications. We kind of are familiar with this in the SSEG development. Experience. How many of us have used age as a proxy for experience? Right? Knowledge. What are some factors that we have been using for that? Is it degree? Is it those other types of points? The second factor is effort. Mental, emotional, psychosocial, and physical. So I think here in the US, we're pretty used to thinking about the mental efforts that need to go into a job and the physical demands. I don't think I've ever looked at the emotion or psychosocial elements of a position. So those are some additional considerations that are going to be different than what you're looking at in building SSEGs. Responsibility, that's the one we're pretty familiar with. Accountability for people, assets, information, finances. So this is that level of responsibility within the organization. I also thinking this is, are they a manager of a function, or are they a people manager, or are they individual contributor type concept is where, for the US nomenclature, and that's where this comes in. And then working conditions, environment, risks, physical context. I think we are familiar with these as well. But this is the building blocks. And I think we can be looking at this as these are the factors for groupings. In the US, we have more flexibility. In the SSEG concept, we are often building groups based on the statistical strength. Are there the 30 and 5 rule? We all know that. These are not discretionary.
Which is of course not a legal rule, but it's a statistical rule for reliability in your analytics.
Right. So we often think about these when we're building our SSEGs. Well, maybe we build it based on family is our grouping, but we control for years of experience as a factor to explain pay. That's not what this directive is saying. Those factors have to go into the grouping, not we don't have as much flexibility. And I think, David, we're going to have a little bit more discussion on the next slide about what can we use to take these points to build our SSEGs?
I want to get there. I want to just
Sure.
unpack one thing a little further. Work of equal value.
Yeah.
Yeah. This is a concept. So it's not comparable worth. It's more narrow than that, because comparability, it involved all sorts of other comparisons of different. But work of equal value, which is assessed, I believe, based on the 4 criteria.
It absolutely is.
But this is a concept that it feels new-ish. We don't have this exact concept in the US. And one that I think the devil may be in the detail in how this develops and evolves.
Well, actually, I think a really interesting piece on that is how many times have we built proactive pay equity analyses,
Yep.
SSEGs, and then we control for grade?
Yep.
Nope. That's essentially, isn't that value? That is work of equal value. If you have placed multiple jobs all at grade 3, you have assigned them equal value in your comp system. So you need to be thinking through, while the data points you've used for SSEGs may be useful, your SSEGs are not going to directly relate to worker categories.
Okay, so let's click down a little bit. Let's get a little more nitty gritty on how to build the categories. So, can you use existing job architecture? Hopefully, yes. Hopefully, yes, and that's our default.
And that goes back to that criteria. We're supposed to have an objective criteria that is gender neutral, that we have notified our employees that we're paying on, our workers that we're paying on. So that should be a baseline roadmap for your categories.
Correct. Then we have the 4 criteria, and this is just another graphic kind of demonstrating that there's no sense that one of them is more important or less important, or that they have to be equally applied. It's as applicable. But those 4 criteria, we want to make sure that we have addressed each one of the 4 criteria when we develop a worker category. Finally, overly narrow. What are we talking about there? Simply job titles. No, the directive is very clear that is not going to be viewed as promoting transparency. In fact, that's the exact problem the directive is trying to overcome. That people were narrowly grouped with job titles, and that in their stereotype, men were assigned these job titles, women were in these lower job titles, lower pay, and that's the problem. And if you only look at job titles, say, we don't have a pay gap at all because everyone here. So that gets into the appropriate comparison, and that it's broader than job titles. And finally, the documentation of methodology. We're going to explain, because the different obligations you have to, if you will, show your homework. Mm-hmm. And this, again, is a little bit of a different concept. Yeah. In the US, we are quite used to going through a variety of exercises, and the 3 of us have been involved with clients. We do this a lot, different ways of doing it, developing the architecture for how we're going to look at pay. We rarely, if ever, show that work. In fact, it's viewed as attorney privilege to advise on compliance. Here, documenting the methodology, and in fact, disclosing the methodology, is going to be one of the outtakes. Yeah. So I think kind of having those in mind as we approach developing what our worker categories are is important to understand that.
There's a lot that you've done with your data to date for US proactive work or state required reporting that can absolutely be used, and the concepts can be applied into the EU. So the first thing, you have gone through your comp system, you've determined what factors you believe you're paying on. You've then gone through your data and said, what factors do I have in a reliable and reportable manner? And you've often cleaned up that data. And so looking at what data points you have in your system and currently use both for grouping and for your control factors, you need to be looking at those and then mapping those data points to each one of the four criteria under the EU directive. So we're not saying you need to scrap all the work. We're actually saying there's a lot of good work you've done in the EU. We just in the US that we just need to pivot a little to apply to the EU standard. And I think there's a lot that you have learned from your US based analyses and your SSEG development that you can quickly and easily apply to your worker category development.
This is something that I think, as organizations kind of come to grips with what these new requirements are, that I think the more forward-leaning folks are beginning, we need to spend a little bit of time doing just the point that you laid out. How are we going to use our existing SSEG-related metrics, data, and information, what's in our HRIS, and how does it map onto these new requirements? Rarely will the SSEGs rarely are you going to be able to just pick them up and drop them in. From our experience, maybe you'll get lucky and that will occur. But this is something that I think benefits from a little bit of thoughtfulness and effort on how you go about doing this.
Agreed. Yeah. Well, we've teased a lot about this reporting and we're kind of built our workers groups for the reporting. So let's move on to the next slide and talk about what the overview of what the reporting obligations are.
Of course. So we got the first piece here, right, which is going to be who's going to be required to report, and that's going to be employers with 100 or more workers, and that's going to be within each member state, right? This is not going to be across the EU or globally. This will be within each member state, whether you have 100 or more. And that data that you'll be reporting on is going to be from the prior calendar year. That's also language directly from the directive. And when you do make that report, that's going to be going to whichever kind of government body the member state has designated to receive those reports. So that's kind of the threshold questions about who has to report.
So there's a couple things on this, right? Calendar year. I thought I knew what a calendar year was. There's a lot of debate about what is, so with the first report, we've actually seen, I believe it's Slovakia, their obligations actually do not require calendar year. They have placed a different time period in different 12-month period. So we'll need to be monitoring each member state to see what is the time period that is going to be reported.
So I can feel employers' heads now really starting to ache as they start thinking, so wait a minute, you may mean I may have different reporting periods depending on which country my work is being done in. And the answer is potentially yes, from what we're seeing. Again, it's very early on, and whether there will be subsequent amendments and alignment, we thought calendar year meant January 1 through December 31. Apparently in Slovakia, that's not how they maintain their calendar. I don't know.
Well, to further complicate that, as the bottom of the slide shows, the reporting schedule for employers with 250 or more workers, that's the earliest when reporting will start. That is arguably June 7th, depending on transposition, et cetera.
Of next year.
Of next year,
yes.
2027. But as you'll see, depending on the number of workers, the beginning of the reporting requirements is staggered out. And whether it's annual or triannual is also based on the number of your employees. So arguably, you could have different reporting time periods, calendar year versus 12 month, and your reporting date may be different for each member state.
Correct, depending on the number of workers you have in the respective country. So, yeah, I mean, being nimble, but I think that clearly one of the key takeaways, you're not going to just peanut butter an EU Pay Directive compliance, assuming you're working in multiple countries. You're going to have to take with these basic concepts, each country, and stand up, there will be core concepts on the transparency requirements, the comparators, et cetera. But all of these reporting deadlines and reporting periods will need to be customized for the country, the applicable country.
One last piece I want to highlight here, not last in importance, is the transparency in the reporting methodology.
Yeah.
So here in the US, where in states and locations where you have a requirement to do reports of compensation, you don't also have to disclose exactly how you built your workers group and exactly how you calculated and did the calculations in the end. You will here. This transparency in the reporting methodology extends to not only the member state to whom you're reporting, but also worker representatives, which is a concept that is in here that, we're going to be partnering with in certain aspects of this directive with worker representatives.
So next slide.
So, David, what is the pay that is being analyzed?
So again, for the US audience, you think, okay, that's easy. It's basically my W-2 stub. I've got that. Maybe in certain situations I deal with stock options, but that's kind of it. Bonuses, et cetera, which presumably would be on your W-2. But you're getting the trend. This is more expansive. The directive is more expansive and more fulsome. So obviously, the ordinary basic or minimum wage, I'll call that your basic W-2 salary, of course, reportable.
Right.
It's the and part. This is the additional. And any other consideration, these are words right off the directive here, cash or in kind, which a worker receives directly or indirectly. Those words are extremely broad. So you think about, and we often started using this as kind of an example in our internal discussions. You have a family leave policy, and one employee draws down family leave and takes the benefit, or you have a college tuition reimbursement or a car stipend or whatever. Several employees are eligible. One employee draws down the benefit, another one does not. So is it based on the value of the benefits that are available or the benefits that are actually drawn down and taken?
Right. That is something that is
to be determined, I think, right? TBD. Yeah.
Right. But this extends to car allowances. I mean, it's any sort of benefit that is being provided to workers. So it's a very broad concept. It's also still a little bit unknown about how you're going to handle employees who are in different jobs during the reporting period. We do not believe it's going to be a snapshot date. So it's going to be for the full 12-month period. So how to handle what is pay is going to be a significant challenge. And what's interesting is we've had a lot of these conversations with EU Council, and we have raised, because here in the US, we're so used to doing this work. We know, okay, is it a snapshot date? Is it a full calendar year? And what are the data problems with that?
What do you do with a stub year? A person works part of the time.
Correct. Those questions haven't been answered yet. And some of the EU Council are like, oh, so, I think that's why I think US employers with EU presence are going to have a leg up and have already anticipated and thought through some of these problems and have probably solved for them in your own proactive pay equity analyses.
No, the collaboration and discussion of these issues is really interesting, but there are a number of, I'll call it TBDs on these types of issues. The care needs to be taken in how we proceed.
Yeah.
People changing jobs, people being promoted, working for partial periods. There's a zillion things built into that. So that's one that we don't have all the answers today. We're working on developing those. And I think that anyone, as you start to step into this, you need to be mindful of that.
So if we go on to the next slide, what has to be reported? A lot.
Yeah. Wow. This is the densest slide we have. I'm just saying, this is the most, yeah.
first four components, everybody is probably going to be very familiar with. It is the basic gender pay gap by mean and by median. And then one is total comp and the by mean, and the other is the complementary or variable components, the mean and median of those as well. So that we're all pretty familiar with, and it's workforce wide within each member state. Then the really important one, highlighted in bright yellow, if you didn't know that's where I was going with this, is you also have to report the gender pay gap by your category of workers. That's why it's very important. Broken down by both the basic pay and the complementary or variable components. What is so important about this pay gap is this is the one that must be provided to your workers, and it has to be provided to your workers' representatives, along with the methodology for providing your workers' categories and your methodology for doing those analyses. And if there is this is the analysis that if there is a 5% 5% or more pay difference by worker category, it triggers the joint pay assessment. And this is the sort of real hook of where you're going to be having to disclose significant amount of information to both the member state and workers' representatives. And on the next slide, we have
Let me just catch a point or two before we jump into the next slide. So I'm sorry, Sarah, let's stay with that, with the yellow. So this breakdown, so this will enable at a snapshot for people to determine whether whether there's a gap in the wages, and then those benefit points that we talked about, they're broken out. 1. 2, when we talk about workers' representatives in the US, we think, okay, that's union. And, most of you don't have particularly a lot of union activity. I mean, the US private sector, we're down up to 6% or so are organized. Some of you have a little more density in terms of organizing. In the EU, as those that are there know, depends on the state, but there are both works councils as well as labor unions. When we talked to our network attorney in Austria, his answer was it's like 99%, 99.9 have worker representatives. Germany, very intensely organized, and the same in France. So this is not a throwaway item, the worker representative, and this is a much more significant item in the EU, again, depending on the particular nation state, country that you're in. But I think generally for the jurisdiction where most US multinationals are doing work in the EU, you're going to find that you have a worker representative, what we're saying generically, worker representative. So just calling that out, and that's a whole level because they have the right to receive the reports, get more information, etc.
Well, I think that also raises an issue. There's so much on this, we can only cover so much in an hour, but what employees are included in these reports? And many of you thinking, well, wait a minute, why the union? They're unionized. Are they even in these reports? Yes. And that is going to be a huge difference in what the way you are thinking about which employees to include in your analyses. I think the US, our default is if they're unionized, we take them out because they're so regimented in their pay. We're not worried about pay disparities based on any sort of protected category. So that's an important distinction here as well.
And this is one because we do some work with a number of senior HR representatives in Europe on these issues. And it's interesting because their response is, we really don't want the government involved in our collective bargaining matters. It's like, thanks, we got this. And the unions, of course, have the same response. I will tell you, when you read what is effectively the preamble, the justification to the directive, in enacting the directive, the European Union sort of called out, we are concerned that collective bargaining agreements may have resulted in job stratification or arrangements, seniority, otherwise, that created pay gaps. And they're trying to break through and look at that. So I'm not sure the strategy of saying if it's subject to a CBA, we don't have to do pay reporting, which I've heard some HR labor representatives starting to talk about. We'll see how that plays out. I think they're going to be called shenanigans on that and probably rolled back, but we'll see. Yeah.
Absolutely.
Yeah. All right.
So let's talk about the joint pay assessments,
Yeah.
the thing that needs to be avoided.
Sure. I'll lead off on that. Happy to. So obviously what we're talking about is when there's more than a 5% gap. So we've figured out who our workers are to compare, who our comparators are. We've done our groups correctly. We've determined there's a 5% greater than 5% gap. We've determined that we can't otherwise justify the gap.
Mm-hmm.
That's important because it isn't just, if you have a 5% gap, you're done. You do have an opportunity to say, but here's why. There are legitimate reasons why. And then assuming that you can't meet that requirement, that you haven't otherwise remedied it. Right. So the employer, there are a couple of off ramps is for employers. So if it's like, oh my gosh, I got 5% problem, what am I going to do? It's all over. No, not necessarily. So you pedal hard to not have to do the joint pay assessment.
What you have to figure out is how are you going to justify that pay difference? So
Right.
I know we've talked a lot about pay gap analyses so far. This is where our traditional pay equity analyses, those regression analyses where we put our groups together and we put in the factors that control for pay differences, which is going to give us, statistical support showing the predictive value of each of the various components that we say is predicting pay, and these statistical results hopefully support that the justification in the pay difference are other neutral job related criteria.
Remember before we talked about the scenarios where you would have to, if you will, show your homework. This is what we're talking about, that if you're doing the joint pay assessment, you run down that list. These are mandatory components to be included. So you are effectively showing your homework, showing what the analytics are in how you arrived at that. Note also that the proportion of male, female workers in a category, this is to deal with whether the possibility that there could be job segregation, or if you only have a grouping that has men only, again, that's not going to pass muster, and there will be transparency, the operative word, applied to that.
And I think, another, not in red here, but the proportion of females and males with pay improvements following return from maternity, paternity, carers leave. This is another area that was called out in the preamble of something that the EU directive is wanting to explore. The most important thing.
Excuse me, and on that concept, folks, it's very similar to when people go on military leave, USERRA leave, the escalator. It's your pay should be as if you had remained at the workplace. That's the concept here.
Correct. I think, but what's important here, do not wait until you're in your reporting period to then determine, oh, wait, the worker category has a 5% or more. Let's see, can we justify it? This is the work that needs to start now after you build their worker categories. But this is, if you are doing proactive pay equity analyses, and you will know that whether there's any pay differences within your employees, right. You will know whether it's justified or not. If your proactive pay equity is showing that, do the remedies now before you actually get into your reporting period. This is the time to take action.
Agreed. So this is really the core, and like anything, just as when we build SSEGs, knowing that we might have to report out, it's helpful to know kind of what the potential end output is. Mm-hmm. And that's exactly what this is, so that we can then engineer and look at our groupings. Because although there's a lot of prescriptive things, you do have some flexibility in worker classifications, worker groups. As we said, that to me is the cornerstone on which the whole foundation is built, to what you had called out at the beginning. Mm-hmm. Yeah. Well,
what do you need to be doing now?
What do we do now?
So it's so
Summertime, have a gin and tonic? No, we should not do that. We should do something more
Only
focused.
after you complete these tasks
Yeah,
can you
exactly.
treat yourself.
Sarah, lead us off with because of our final thoughts on what we should be doing now.
Sure. So, I first kind of touched on those pay transparency concepts. So really one of the first pieces is going to be reviewing your policies and your procedures and things like that. So what do you have in there that's regarding pay disclosure, or how do you get information to folks? So you want to check those policies so that they're compliant with the directive and kind of those obligations to be providing pay range information before hiring, whether folks can talk to one another about pay, and really any other kind of policy related matters that need to be addressed.
And then flowing right off of that, as you are looking at your how you set pay and the determinations and making sure they're in compliance with these with the regs, make the modifications as needed. Be building those worker categories, starting to reading your policies, developing the factors and structure based on how you pay, move that right into the development of your worker categories so that you have those prepared and ready to go.
Finally, this proactive pay equity analysis. That is a new requirement, but you can basically bench test what that would look like. You know what the report requires. There's, if you will, complete transparency on what those reports are going to require. Don't wait to do that for the first time when you have to file a report. Be prepared ahead of time. Do the reports, see how they look, see how all the pieces fit together. To the worker categories, the factors you've used, are they lining up? If not, while we have the benefit of time, go back and fine tune those. We can do that. There's no restriction on doing that. But once we get into the I'll call it game mode of having to actually file the reports. They are prescriptive, and ideally we will be well prepared. We're going to know should be no surprises at this point. We should be able to, once we develop the categories, we have the monitoring, we have the HRIS system, the capability of doing this to know whether we are going to have that 5% gap or not.
And I think I kind of would like one last little chime in too. We have a minute. I think step 3 and 4 go together, right?
Yes.
You should first do your proactive pay equity analysis to really test for any disparities, make those remediations, and then run some sample EU simulations. If you say, well, my member state hasn't implemented and transposed it yet, how do I know? That's okay. The proactive is how you structure pay. That is not determinative on the directive. That's you testing whether you're paying in accordance with your policies and practices. The EU simulation, you'll be as close as you can. You can use other member states as models, but I wouldn't be on the back foot on this, waiting for your member state to implement.
Yeah. And this reporting, keep in mind that the reporting is going to go to the member state. Those of you that have works councils or unions, they are entitled to receive a report. Individual employees can receive the report. So there's a lot of stakeholders. There's a lot of not just traditional labor, there's a lot of human resource kind of ripple down and ripple out that these reports potentially may trigger. So you want to be sure that you are comfortable with a fairly highly publicized anticipate that it could be fairly highly publicized, the report about your organization. And you feel good about that because you're, like everyone else, competing to attract talent, retain talent, all of that. And you get a bad report, that is not good. I mean, we've learned that from the UK and other pay reporting, and that is part of the design of this whole system to create those pressures on companies. They have bad reports, they're not going to do well. So that is all baked in. All righty. Anything else that we want to add? Because I think we've covered a huge amount in a very short period of time.
I'd like to highlight our resources, though.
Yeah, let's do that. And Sarah, Liz, why don't you jump on that?
I think it's important to know if you go out to our website, we have a EU Pay Transparency Directive page. You can find it linking at the top or the link here. The list of our partner council are there. We're also going to be implementing a transposition interactive map that's going to be coming up we have resources. They're going to be posted on that site. So please stay tuned and check out that. We also have done or will be doing a podcast on the EU Pay Transparency Directive. And if you want to watch this webinar again, it'll be available.
So we have all these materials and these highlight the EU, but the materials actually are obviously much broader than that. And so please, as they say, watch this space because we do put up a lot of, and we get a lot of great feedback on the material that we post. So, all right. Well, I want to thank Liz and Sarah. Thank you both. And thank all of you for joining us today. Sarah.
We'd like to thank you all for joining us today. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.